Hello students, welcome to AKS. In this video, we will be discussing about the salient features of India's constitution. Number 1, India's constitution is called as an written constitution. What do you mean by written constitution? By stating that India's constitution is a written constitution, we mean that it has been specifically drafted by the Constituent Assembly, which we have already discussed. What is an unwritten constitution? Unwritten constitution is one in which important laws made by the parliament are collectively called as a constitution. So, for example, in UK, the parliament of UK passes different laws. Those laws itself become the constitution. So, they do not have a particular constituent assembly to draft a final constitution. So, let us try to understand the differences between a written and unwritten constitution. In a written constitution, the constitution is supreme. The constitution is supreme. So, because it is the constitution which gives the powers to all the three organs of the government, namely the legislature, executive and the judiciary. So the legislature, that is the parliament, the executive, that is the government functioning, and the judiciary are creatures of the constitution. They are created by the constitution, and thus the constitution is supreme in a written constitution. Whereas in an unwritten constitution, it is the parliament which is supreme. It is the parliament which is supreme because parliament decides which organ, namely the legislature, executive and judiciary, will get what powers, and thus the parliament is sovereign. Thus the parliament is sovereign when it is an unwritten constitution. Also note that in a written constitution, there is a necessity to have an independent judiciary. So as to ensure that the judiciary gets powers from the constitution itself, so as to protect and interpret the constitution. So whenever there is a written constitution, the independent judiciary will be existent, and this independent judiciary will get powers from the constitution itself to protect and interpret the constitution. In an unwritten constitutional system, there is no independent judiciary as the parliament decides the powers of the judiciary. For example, in UK, the UK High Courts Act was passed in the year 2010 to create the Supreme Court. So it was a parliament which created the Supreme Court in UK. Okay, that's why the independence of the judiciary is in the hands of the parliament, but not the constitution. Then, in a written constitutional system, there is a difference between the ordinary law versus the parliamentary law. So there is a difference between the ordinary law and the parliamentary law, because ordinary laws are passed by the parliament, whereas the constitutional laws are passed by the Constituent Assembly. So there is a draft or the existent constitutional document in which various important laws are already existent, whereas the parliament keeps adding certain laws. So there is a difference between parliamentary law and constitutional law, okay, when it is a written constitution. When it is an unwritten constitution, the laws made by the parliament itself become the constitution. So there is no difference between the ordinary law versus the constitutional law. So the ordinary laws and the constitutional laws are more and the same. Also, when it is a written constitution, it is difficult or it is a rigid constitution. Why do we call that? As the makers of the constitution use collective wisdom to create a constitution, the procedure to amend the constitution is more difficult when it is a written constitution. There is rigidity, there is a partial rigidity. The procedure to amend the constitution, the procedure to tweak or make amendments to the constitution is difficult in a written constitution. In an unwritten constitution, there is more flexibility. What do you mean by this? That is, the procedure to amend the constitution is very simple. Just like an ordinary law is passed by the parliament, in that way the constitution itself is amended, because there is no difference between constitutional law and ordinary law in an unwritten constitutional system. The next important salient feature is that India's constitution is federal in nature. So before we understand what do you mean by federation, we have to try to note that there are three kinds of political systems across the world. Okay, namely a federal system, unitary system, and a confederation. So we will try to know each of them. How do they exist and function? So when it is a federal constitution, you have a division of powers. You have the principle of division of powers. What do you mean by division of powers? That is, the powers between the central government and state governments are divided as per the constitution itself. So it is usually in a written constitution, the powers are guaranteed between the central government and state government. So there is the division of powers is mentioned in the constitution itself. Also, there is a need for an independent judiciary. There is a need for an independent judiciary for the effective functioning of a federal system, because this judiciary will protect the division of powers and will also look into the implementation of the division of powers, and it will also protect the interests of the states when the central government is overpowering the states. Okay, so that's why for a federation to exist, there is a need for division of powers, there is a need for a written constitution, and there is a need for an independent judiciary. Also, in a federation, the states cannot usually withdraw from a federation, because all the states give up their individual sovereignty to form a unified political system of common political interests. Thus, to prevent the center from encroaching the powers of the states and to guarantee the autonomy of the states, an independent judiciary is essential for the functioning of a federal system. So that is why you see how the balance between the central power and the state's powers is maintained in a federal system. Now let us try to understand what do you mean by a unitary political system. It is that system in which there is only one government, that is the national government. There is no states. Even if the states are to be created, their powers are decided by the central government but not the constitution. The states are created by the decision of the central government. Okay, for example, UK created the states of Scotland and Wales in the year 1997 by a parliamentary law. So who created these states? It is the central government through the parliamentary laws. But whereas in India, the states have been created by the constitution itself. Thus, there is no constitutionally guaranteed division of powers between the central and state governments in a unitary system. However, so in unitary political systems, there is no division of powers. However, there could be separation of powers between the legislature, executive, and the judiciary. Okay. Usually but not always, unitary political system has an unwritten constitution like in United Kingdom. Also, there could be unitary political systems with written constitution like in Sri Lanka, Japan. Okay, they have unitary political systems but they have a written constitution, so that the judiciary, there is an independent judiciary which will protect the interests of the different political constituents. Okay. Now let us try to understand what is a confederation. A confederation is a collection of sovereign and independent states. It is a loose association of sovereign states which form a political grouping called as a confederation, who will transfer some subjects or some powers to a federal government, and there will be a national government for each sovereign state. That is, each sovereign state within a confederation will have its own powers. However, they form a national government or a national representative body which will be given some powers by these national governments themselves. For example, you have European Union. So it has a government called European Commission and has a European Union Parliament. So laws made by European Union Parliament are applicable to all nations but are not binding on them unless there is a consensus. That is, these national governments should also pass those laws. Only then that these laws made by the EU Parliament and the EU Commission will be applicable. Usually issues related to security, policing, international trade and international policy are given to this confederation representative bodies. So in a confederation you have a federal government as well as various national governments. Each national government has its own sovereignty and own powers. Okay. So laws made with the federal government will not be applicable unless the national government decides to pass the law in their country in the confederation. So in a confederation, laws reach the people through the national government only. Member countries can withdraw from the confederation any time as they are independent and sovereign. However, in a federation, as we discussed, member states cannot usually withdraw as they have voluntarily surrendered their sovereignty to the national government. So, in the confederation, even in the subject of a center, there is a need for consensus for every decision made by the federation, for every decision made by a confederation representative body, there is a need for consensus, that is, all members should agree to pass that law. Only then will the law be applicable. So, that is the difference between a federation, unitary political system and a confederation. Next important salient feature is that India's constitution is partly rigid and partly flexible. What do you mean by this? When you say it is partly rigid, you can see that the procedure to amend the constitution is partly rigid because there is separation between ordinary law versus constitutional law, which we already discussed, and also the procedure to amend the constitution is difficult. That is why you say that India's constitution is partly rigid. Why do you call it partly flexible? We call it partly flexible because most provisions of Indian constitution can be amended by an ordinary law. Okay, amended by ordinary procedures or by like an ordinary legislation without a constitutional amendment. So what do you mean that they can be amended as an ordinary law? That is, these laws can be amended by a simple majority of the parliament. Okay, so that is why you call India's constitution is partly rigid and partly flexible. The next important feature is that India's constitution is the lengthiest constitution in the world. So presently, India has more than 450 articles, 24 parts and more than 12 schedules. It has what is the reason for the lengthiest constitution? Because India's constitution has all provisions regarding the states enumerated in the constitution itself. It took the best from other constitutions of the world. So the constitution makers of India took various provisions. They did an in detail study of the various constitutions of the world and tried to incorporate all the important ingredients in the Indian constitution. Also, India's constitution has detailed provisions regarding governance, regarding states, regarding fundamental rights. The provisions related to fundamental rights are enumerated in the constitution itself, and also directive principles of state policy. Like this, major provisions are enumerated in the constitution itself, so that there is no scope for further litigation, or there is limited scope for litigation. That is why lot of provisions have been enumerated in the constitution itself, and thus this made the constitution bulky. And also, India has elaborated description of directive principles of state policy which have been borrowed from Ireland. Many safeguards related to weaker sections and privileges of the scheduled castes and scheduled tribes, as well as women and children, have been mentioned in the constitution itself. So that is why India's constitution is supposed to be the lengthiest constitution in the world. India's constitution is quasi-federal. Why is it so? This term was coined by KCVR to describe the Canadian constitution. So what do you mean by saying that India's constitution is quasi-federal? While having all the features essential for a federation, some of the unitary features are also there in India's constitution. So all the essential federal features are there in the constitution. However, there are many unitary features. So to decide whether a particular feature is a federal feature or a unitary feature, we have to know whether that particular feature is diluting the division of powers. If a particular feature of the constitution is diluting the division of powers between the central government and state government, then such a feature is called as non-federal feature. Okay. So having known this, now try to understand which is an ideal federation. An ideal federation is one where there is strict division of powers between the central government and state government. Example, United States of America is an ideal federal country because there is strict division of powers. However, in India, we have division of powers, we have federal system, but there are some non-federal features also present in the India's constitution, which we will discuss now. So some of the non-federal features like single citizenship. Single citizenship is existent in India. That is, there is single citizenship within the federation. It is a non-federal feature but not a unitary feature, as it is not affecting the autonomy of the states and not interfering with the division of powers. So that is what is the difference between a non-federal feature and unitary feature. When it is a unitary feature, it is interfering with the autonomy of the states and interfering with the division of powers. Whereas in USA, you have dual citizenship. That is, within the country of United States of America, you have citizenship given by the central government or the federal government as well as the state government. Okay, another important feature which makes India non-federal feature is the equal representation given to the states in the upper house of the parliament. Equal representation in the Rajya Sabha. In India, you have equal representation given to all states in the Rajya Sabha, irrespective of their population, irrespective of their geographical size. All states in India have equal representation in the upper house, that is Rajya Sabha. Whereas in USA, you have unequal representation in the Senate, that is a non-federal feature. So depending on the population of each state has unequal representation in the Rajya Sabha, in the Senate of USA. Number 3, every state has a separate Supreme Court and a federal Supreme Court is there at the central government in the United States. So the Supreme Court of the states deal with the disputes on the basis of state law, and the federal Supreme Court decides disputes on the basis of federal law in the United States of America. However, in India, you have Supreme Court as the apex court. That is, you have a single integrated judiciary. Okay, you have a single integrated judiciary system in India where Supreme Court is at the top of the chain of the courts and disputes can be on the basis of the state law as well as the central law. Thus, the single independent court, that is the Supreme Court, which is an integrated judicial mechanism in India, which is the basis for a non-federal feature. This is usually, when you call it as a single integrated judiciary, some people also argue that it is a unitary system. Okay. Also, in India, you have the Unified Comptroller and Auditor General, or the CAG, which audits the functions of the state and central government, and which is a unitary feature as well as non-federal feature as it affects the states. So this Comptroller and Auditor General audits the accounts of both the central government as well as the state governments. However, in USA, you have a separate audit officer for the central government and state governments. So then another important feature in India which makes it non-federal is the All India services, like the Indian Administrative Services, Indian Police Services. So these All India services implement the central laws as well as the state laws, and they implement the central government programs as well as the state government programs, and function as the common executive representing the central government and the state governments. So this is a unitary feature and non-federal feature, as the All India Service officers treat the central government, state government as one, and there is no distinction or there is no proper division of powers regarding the same. However, in USA, you have separate services for the federal government and state government. That is, you have something called as federal police and state police. Also, the system of governor in India also represents some non-federal features. Thus, India's constitution is much more non-federal or quasi-federal in nature, or you can call it as partly federal and partly non-federal in nature. The next important feature is that India's constitution is a three-tier federation. That is, there is a central government, state government, okay, and the local bodies, local governments like the PRIs, Panchayat Raj institutions, and the urban local bodies. So in this way, you can see there is a three-tier federation usually in India. However, in fifth schedule states, we have something called as fifth schedule states, there is a four-tier federation because they have tribal advisory councils and district advisory councils. The last feature that we have to discuss is that India's federation, the constitution has made the center deliberately strong. Okay, in India's federation, the constitution has made the center deliberately strong because the residuary powers are with the central government, and the central government or the union government has more financial powers compared to the state governments. So you can see that. And also another reason why we are saying that India's constitution has made the central deliberately strong is that the union list consists of more number of items and more important subjects of the government compared to the state list. So that is why you can say that India's constitution has made the central government more stronger compared to the state governments. This was done so as to deal with the challenges of nation building, and thus the center was made deliberately strong to protect the unity and integrity of India. Thank you.